All right, everybody, welcome back to the Learning Out Loud podcast. I'm your host, Dustin William. I have my co-host with me, Whitestone.
I shall now attempt to show how the most important of these principia have been crystallized into the pithy form of maxims and have influenced and developed that grand system of truth known as equity jurisprudence.
The power is neutral. It's sitting in the quintessence until you invoke it. All right, welcome everybody back to the Learning Out Loud podcast. We have made it all the way to episode 21, and I am very excited about this one. We are going to do a deep dive, stepping back into equity in our law series. We just covered the first four stories of redemption out of the Bible in our last show. And in this show, we're going to begin to cover the equity of redemption in the exclusive equity jurisdiction. But before we get any there, let's get the business out of the way. I am your host, owner and producer over at truelifeproduction.com. Dustin William, that's where you can find all of our work. It's up on the screen right now. All you got to do, scroll right down here. That gets you to All Aboard. You can watch all of the shows ad-free here. And then you can also check out Article 3 articulations. This is the deepest dive you're ever going to see on the slaughterhouse cases. It's over a 3-hour video on the slaughterhouse cases. The Thought Crime Dojo, not very active anymore because I'm spending a lot of my time on the podcast, which is right here. Click this. First hour of the show is here. You can watch it free, ad-free there if you don't want to watch ads on YouTube. The foundation episodes right over here. These are the first 10 hours of the podcast, completely free for you. Both hours of the podcast are free. That's 20 hours of content specifically focused on equity jurisprudence. We break down the entire 1903 Tully speech to the bar. So that is where you can get started. And if you like what you hear, then you can click on become a member. And for, like everybody used to say, for less than a cup of coffee, you can become a member of my channel. And now for less than 2 gallons of gas, you can become a member of our website. That's $8 a month. So that's it for the business, though. Let's get into it. Let's introduce our co-host before we get into our opener here. Whitestone, how is it going, man?
Oh, doing great, doing really good. I'm really excited. Every time we get into this, I know this is not an equity podcast, but we can never not talk about equity.
It might as well be, but
we might, yeah. But really, if equity is the basis of all things, then truly, eventually, it's going to trickle back down to some sort of equity reference. And I think what we're getting into today with Pomeroy, some of his writings and some of his life, it's absolutely foundational, and I'm very excited about it.
Yeah, absolutely. I love it. Yeah. And I've got the show set up in a specific way today to kind of walk everybody through this journey that we're going on here. But before we get into Pomeroy, you know me, I'm a Bible thumper over here. So I'm constantly in these things, constantly looking for stuff. And what I wanted to open with today is actually my favorite passage from the Bible. We're not going to read the whole thing. We're just going to read the first 2 verses of it because I find it specifically relevant to what we're talking about today, because we were kind of talking about this a little bit off air. What I see equity jurisprudence as is kind of the armor of God. You know, this is the armor that we put on in the spiritual realm, and you'll never hear me stop saying this. You can't really get into this whole, quote unquote status correction, equity journey, whatever you really want to call it, the law journey. Well, you can get into it, but you can't get headed in the right direction until you find God first. And that's why, I stay in my Bible, and that's why I'm setting up the show in the way I'm setting it up. Is we're going through the Bible and studying we're going to go through the Bible and study all of the stories of redemption that we find in there, and then in between those, we're going to do like a stagger step. We're going to go, and that's what's starting today. We're going to start studying the equity of redemption, which is found in equity jurisprudence. And we're going to see if we can correlate these 2 subjects, because I do believe firmly in my heart that these 2 subjects are extremely correlative, and you find equity all throughout the Bible. everywhere. Like we were talking about this off the air a little bit too. Another hero of mine, Martin Luther, the man who started the Protestant Reformation, he actually came to his conclusions. Well, came to his his revelation per se, through reading the book of Romans in the Bible. And what he saw there is basically what he saw was the distinction between the Old Testament law and the New Testament gospel, is what he called it, but that is what we refer to as equity. And so our whole distinction here is the difference between law and equity. And John Norton Pomeroy is such a good man to jump off on this point, because all of his writing is just so it's just so finely crafted. He's such an awesome author, and he is about 100 years after. Well, not quite 100 years. He was born 1828, so he's about 60 years after Joseph Story, and he builds on top of Joseph Story's work, which is a man we've talked about before. So, but before we get there, I want to open up with my favorite Bible passage, and I'm going to read it, and then I'm going to have Whitestone read it out of his Masonic Bible, because there's a very there's something missing in here between the Geneva Bible, which is what I'm going to read out of, and the King James version. So, everybody, let's see if we have some keen listeners out there, and see if you can find the distinction before we point it out. So this is Ephesians 6:10-12. And I am reading out of the 1560 Geneva Bible. So verse 10, finally, my brethren, be strong in the Lord and in the power of his might. Put on the whole armor of God, that ye may be able to stand against the assaults of the devil. For we wrestle not against flesh and blood, but against principalities, against powers, and against the worldly governors, the princes of darkness of this world, against spiritual wickedness, which are in high places. So that is Ephesians 6:10-12. And that is out of the Geneva Bible. So you want to read it out of your Masonic Bible?
Yeah,
Whitestone?
absolutely. It really wasn't too different, other than, normally we just got grammatical structuring and different words, but this is this is out of the Masonic Bible, Ephesians 6:10-12. Finally, my brethren, be strong in the Lord and in the power of his might. Put on the whole armor of God, that ye may be able to stand against the wiles of the devil. For we wrestle not against flesh and blood, but against principalities, against powers, against the rulers of the darkness of this world, and against spiritual wickedness in high places.
So did you catch what was missing, though?
I think it was in 12.
It is in 12. Yeah.
Yeah,
Yep.
so it was right after we wrestle not against flesh and blood, but against principalities, and
Against
mine says
powers.
against powers, and then against rulers of the darkness of this world. And yours says what?
And mine says, so in between all of that, there's one very important line that is missing. And the line that is missing, so I'll read 12 again. For we wrestle not against flesh and blood, but against principalities and against powers. And this is what's missing out of the KJV. And against the worldly governors. That's not in yours, is it?
No, it's not.
Yeah, and against the worldly governors. It's interesting that that's what they chose to take out of that passage in the KJV, is it not?
Is governors all lowercase?
Yes, yes, it is.
And then
Yep.
and then yours also says against the rulers of the darkness of this world.
It actually says princes of darkness.
Oh, wow.
Yeah, yep. So governors and princes. And then it completely takes out governors and replaces princes with rulers in yours.
Wow.
Yeah, so that's a pretty spicy little nugget there in the distinction. So everybody out there reading the KJV and stuff, these are the kinds of distinctions that are in these books. And like I'm not talking shit about the KJV at all. I think it's a wonderfully written book. And if you read the front portion, the introduction or the letter from the author or the editors or whatever, they explain to you in there the reason they wrote the book the way they did is to make it a more easily remembered they wanted to make the passages more easily remembered and more like a sing-songy type of thing. That's why it's written in that fancy language, because they wanted farmers to be able to like put it in like a tone, a sing-songy tone in their head, so they could more easily remember the passages as they're working on their farm and stuff. Because that's what people were reading. They were reading the Bible, the works of Josephus, which was a first century historian, and they were reading Blackstone's commentaries. That was basically all the literature that they read. So they wanted to make sure that these farmers could easily remember the passages of the Bible. But that is all I wanted to point out from that. Unless you got anything you want to add to that, Whitestone, we'll move on to Mr. Pomeroy now.
No, well, actually, I will say that, I talked to a guy that does, we talked about this off air, but he sits in a park at a table, and it's, he's got a Bible out there and it says Bible Answers. And it's part of that new trend where people go and sit at a table and, ask questions for somebody who's got some knowledge. And, I had asked him about the Geneva Bible and the old KJV and the language, and, that sometimes it can be kind of hard to, you really got to parse through the language. He's like, oh, well, if you really, and this is what he said, almost verbatim. Well, if you really want to pump it up and put some air in your tires and, really kind of get through it, I read what is it? The NESV, what was it?
The NESV, yeah, New
Yeah, the
English Standard Version.
NESV, or, some of these, newer translations there, they make for a much easier read. And I was polite. I didn't say anything. It's like, well, there's a reason I don't read those, is because they take out a lot of the language that would really bolster somebody's understanding of what we're reading.
Yeah. I mean those words they took out of the Geneva Bible, or they took out of the KJV. Those extra words really pack a punch, bro. And
Yep.
especially in the context of the Protestant Reformation, there's a very specific reason why John Calvin and John Knox and all the other people involved in writing the 1560 Geneva Bible. There's a reason they put that in Ephesians 12, 6:12. They're
Because
they were. Go ahead. Yeah.
I was gonna say, because the word princes, it evokes a very different feeling and a understanding than just the general term ruler.
Yes. Yes. And worldly governors. They were very
And
specific. Worldly governors.
governors.
Yes. That means a king. That they're fighting the worldly governor, not the governor on high, the one in heaven. The worldly governor, the one down here. That's who you're battling. You're battling
And who was
their
it
principles.
that had temporal power, who wanted to enforce the temporal powers? They wanted to enforce and extend the temporal power of the Pope as well as spiritual, because they wanted spiritual and temporal power. And so it's like, well, that's who we're fighting against, is against the worldly governors.
Yes, yes, exactly. Exactly. Yeah, so yeah, I just thought that was a very apt little passage for us to open up with, because like I said, I see equity jurisprudence as the armor of God. And I'm not going to put words in his mouth, but I do believe that maybe John Norton Pomeroy kind of saw it that way too. Because as I'm going through and I'm reading his literature and stuff, he is very specific in the way he's talking, and he's writing in a way where he understands what's about to happen to our country, and he wants to know, and he wants people to know that there's a different way, and he wants people to know that it doesn't have to be this way, and there is always remedy, and he's going to show you the remedy, and he's going to put what a thing he's really good at is he is good at pointing out the distinction between the common law and equity, which is what me and Whitestone are constantly talking about. There is this big, giant gap between common law and equity. And that's, yeah, go ahead. Do you want to?
I was going to say, I think he's probably almost single-handedly responsible, as we're going to see, for systematizing in a very erudite way the doctrines of equity, so they did not get lost or merged once the courts of law and equity were merged. He wanted to preserve the doctrine as a separate and distinct thing and not let it get swallowed up and mixed in with a lot of the codification that was going on, which I think is so important, that he put his foot down and says, no, this doctrine must stay separate. It must stand on its own, so that way people understand that law and equity were merged in procedure and form only, but not in substance. And so for that, I think he should be commended.
Yeah, absolutely. And he did all of this pre-merger too. I mean, he died in 1885. So for him to have the foresight and him to, he's in the mix right when like there's a lot of these little ninjas coming in that are trying to change the system. I think Oliver Wendell Holmes, he's getting into the Supreme Court right after this. This is really when everybody's like turning on Joseph Story in the Supreme Court. Like a lot of people didn't like Story at the end of his career because he was a Federalist and everybody was all about states' rights. It's a big, long, complicated thing, but that was kind of the environment. And but I think Pomeroy kind of really saw under everything, and he saw what was really coming, and I think he really found it really important to uh to make these distinctions here. And actually, as we'll find out later, he wrote an entire treatise just on this subject, which is something we'll probably get into after we get through this equity of redemption study that we're doing of Pomeroy's. So before we jump into Pomeroy, I guess I'll talk a little bit about how I have this episode set up so everybody knows here on the first hour. There is incentive to go over to the second hour on the Learning Out Loud podcast. So what we're going to do here is we're going to talk about a little bit of the life and times of John Norton Pomeroy, why he is relevant, why his work matters, how he was trained, who he came up, a general overview of his life. And then from there, we are actually going to we're going to talk about a Supreme Court case that happened during his lifetime in 1877, about 10 years before he died. And that is the Pong v. Davis case, 96 US 332. And we are going to break down this case. This is a case on mortgages and the equity of redemption. And the reason I want to kind of primer you guys with this case right here is because there's a lot of people out there that just think equity is, this bullshit thing, and it doesn't actually matter, and everything's been merged. Even the rules of equity are merged with the federal rules of civil procedure and stuff. And we've actually read the Grupo case. We know that's not true. We already know that's not true. Anton Scalia told us in no uncertain terms that nothing has changed in the equity jurisdiction in the federal court since 1789 with the original Judicature Act. Everything is the same. And when there's a conflict between, what is it, Whitestone in the Judicature Act, when there's a conflict between the rules of
Yeah, when
equity,
there's a conflict between the rules of the common law and between the rules of equity, equity shall prevail.
equity shall prevail. Okay, so, and that's why I want to open up with, or not open up, but finish this first hour breaking down a Supreme Court case specifically focused on the equity of redemption, just so people know, hey, this is the Supreme Court talking about it. This is literally the highest authority in the United States talking about the equity of redemption. And this is not a weird concept to them. This is equity of redemption is a very, people in the law, they know, like, they know about these things. It's just and even in the federal rules of civil procedure, equity of redemption still has a lot of power, but it has even more power in the exclusive equity jurisdiction, which is the case that we're going to talk about. In the exclusive equity jurisdiction. We'll break it down for you guys so you can understand it. And then in the second hour, we are actually going to go through Pomeroy's work. We're going to go through sections 363 to 377 of Pomeroy's equity jurisprudence as administered in I'll get the actual title for you guys. A treatise on equity jurisprudence as administered in the United States of America, written in 1881. That is the book we're going to break down. We're going to start on his general theory of equity and his what he ranks as the most important maximum equity, which is ought to be done. Equity regards as done that which ought to be done. So, all right, without further ado, let's start talking about Mr. Pomeroy here. All right. So that's a picture of the man right there. He was born April 12th, which is coincidentally my birthday. There's a nice little synchronicity there. But he was born, John Norton Pomeroy, born April 12th and died born April 12th, 1828, died February 15th, 1885. He was an American jurist, a law professor, and legal writer whose 7 treatises systematized Anglo-American equity doctrine for the post-codification era. Born in Rochester, New York, and trained through an office apprenticeship rather than a formal law school, Pomeroy built a scholarly reputation that set him apart from virtually all contemporaries. He was simultaneously a practicing attorney, a faculty member at two major law schools, and the most prolific legal treatise writer of his generation. The defining problem of his career was the relationship between equity jurisprudence and the reformed code procedure introduced by the New York Field Code of 1848. How to preserve the doctrinal content of English equity within American legal systems that had formally abolished separate courts of equity. His treatise on equity jurisprudence as administered in the United States of America, the largest of his works, answered that question with a comprehensive and intellectual rigor that made it the standard professional reference on American equity for more than half a century and earned sustained citation in appellate courts from coast to coast. He served on the faculty of the University of the City of New York from 1864 to 1871 and founded the instructional program at Hastings College of Law, University of California in 1878, where he served until his death. So that is just a general overview of the man, John Norton Pomeroy, who he was and why he is important, and why he's still important today. Yeah, we should actually look into this New York Field Code, because it seems like that must have been what he's seen was coming there. That must have been, maybe that was really the first attempt of merging the law doctrines there.
I think it was. That was the first attempts to, hey, we're going to start merging these into, one civil action. He went, no, no, no.
Yeah. He said, I need to get on top of this and let everybody know there's a remedy here. Yeah, because actually, in this a treatise on equity jurisprudence as administered in the United States, that's actually, he's got 4 parts on equity jurisprudence, and then he's got 2 whole books on just equitable remedies. Like now, if you find them on archive.org or whatever, the one I read out of is all of these editions put together. It's the most recent one. It's just easier for me to go through. But yeah, he's got 4 on equity jurisprudence and then 2 on equitable remedies. And like I say, he wasn't trained in a law school either, which is another thing I really like about him, because I'm not trained in a law school either. So,
Yeah.
I always find that endearing.
What's funny is he was trained through office apprenticeship. And for me, It's like, if you're working in an office, you're working in the capacity of like a secretary or a clerk or, someone of that nature. So he got to see behind the scenes what goes on at the administrative, clerical, or secretarial level, and probably was doing things like, working with deeds or working with, a lot of these other documents and, probably trusts and things that were arising. So eventually later on, when he went into law, I think those 2 schools came together for him. And that's why he was so powerful, is because he was on the other side of it. And even in this outline, it talks about how he did not come at this from a purely scholarly level. He actually had experience on the other side to back it up. And then when he got into the scholarly law side, he was already way ahead of the game because he knew.
Yeah, people don't give enough credit to experience when really experience is everything.
Yep.
But people only give credit to really do you have a degree? But it's like, he wasn't trained in there. He actually got to solve, and you're probably exactly right. That's probably exactly what happened there. Is he was trained in an apprenticeship program, so he's seeing how these mechanisms actually work, and not how a law school says they're supposed to work. He's seeing how they work in substance and not in their form. So. We'll go on to Pomeroy's education and intellectual formation. Pomeroy's legal education followed the apprenticeship and model standards of his generation. After graduating from Hamilton College in 1847, where the classical curriculum in Latin, rhetoric, and logic and moral philosophy shaped the systemic disposition evident in all his writings, which we just did a couple shows over the trivium, which is grammar, logic, and rhetoric. If anybody wants to check that out, episodes 11, 12, and 13. He briefly taught school before reading law in Cincinnati in the office of Senator Thomas Corwin, a prominent Ohio attorney and politician. He completed his preparation under Judge Henry R. Selden in Rochester and was admitted to the New York bar in 1851. The intellectual lineage that shaped his jurisprudential work flowed primarily from three sources: the classical common law treatise traditions, Blackstone, Kent, and Story; the codification debates of the 1840s and 50s, David Dudley Field's New York Reform Movement and its critics; and the English equity reports and treaties available through contemporary legal publishers. Pomeroy read Joseph Story's commentaries on equity jurisprudence early in his career. The work he would ultimately extend, challenge, and in important respects supersede. Where Story organized equity around English historical origins, Pomeroy organized it around American practice and the specific questions posed by code procedure. His father, Enos Pomeroy, one of the first practicing attorneys in Western New York, provided an early model of practicing scholar attorney that shaped his dual professional identity as writer and advocate. 9 years of private practice in Rochester, 1851 to 1861, gave him the practitioner's perspective that distinguished his treatise from purely academic works. He later noted with dry candor that his Rochester practice had produced, quote, little if any business, a circumstance that paradoxically confirmed the scholarly temperament that the practice years had allowed to develop. When he entered legal academia in 1864, he brought more than a decade of experience navigating the gap between equity doctrine and code reform procedures that his treatise would spend 20 years addressing. So, very interesting upbringing and very untraditional, and actually very untraditional in very much the same way as Joseph Story. That's kind of how Joseph Story was trained. If we're remembering right, Joseph Story actually trained under John Marshall, and in an informal way. Joseph Story never went to law school either. So kind of seems like a trend here. These guys that aren't going to law school kind of understand the law a little bit better than anyone else.
And they were trained through the method of the trivium too, which,
Yes,
like you
yes, they
said,
were classically trained.
we've already
Yeah.
covered why it is that's so important.
Yep, we did 3 whole episodes just on the trivium. So yeah, and Joseph Story was actually trained in that very specific way, through the trivium method of learning too. So there's obviously something here. These guys are tapping on something. There's something. There's a reason why we're so attracted to these guys. So let's get into his academic and professional career. He was at the University of the City of New York from 1864 to 1871. In 1864, Pomeroy accepted a chair of professional law at the University of the City of New York, later New York University School of Law, where he eventually became Dean of the Legal Faculty. He received an honorary LLD from Hamilton College in 1865. During his 7 years at NYU, he published two major treatises, an introduction to municipal law and an introduction to constitutional law of the United States, and established his reputation as the foremost systemic writer on American public law. In 1871, he returned to private law practice in Rochester, citing the limited legal business his scholarly temperament had attracted during his early practicing years. Which I find that interesting. He returned to private law, and because it seems like they didn't really like him. They didn't like his scholarly temperament up there in the
because
university.
When I read that, I was reading through that timeline last night, and he was saying that, well, I was a practicing attorney, but it didn't really produce any business, and they're saying that is because of his scholarly temperament. He didn't have the right temperament to really have the teeth as a practicing attorney. And so he's like, well, that's why you probably wouldn't do very well making business on that, is because you look at it from more like a scholarly academic standpoint. Even though he's got experience, he's like, I don't know. I think maybe I just go on the private side because I can do equity over there.
Yeah, and I think that really seems like that's what the distinction was too. Because I obviously, bar attorneys, we talk about bar attorneys all the time, and they're a different breed, dude. They're just a different breed of human being for sure.
Yeah.
and I don't think he was fit for that kind of office.
No, and I think that he saw also, they mentioned here the code debates, the codification debates, and he was saying that, there's a lot of literalism in terms of interpretation of these codes, and it's really not in line with equity jurisprudence. And so maybe that's why he kind of lost his heart in it. It's because I can't, sit here with these literal code interpretations when there's other things that could be, that could be
Yeah,
used.
there's other things we're not talking about here. Yeah, absolutely. And and this is right in he leaves in 1871, which that's a very interesting year in the things that we study too, what they
Yeah. The
they
Organic
get
Act of 1871, where Washington, D.C.
exactly.
incorporated
Yeah.
itself. He's like, all right, I'm out.
Well, it didn't incorporate itself. Washington D.C. was actually incorporated in 1821, but what the Organic Act was, they gave Washington D.C. a government. That's what that did, which is even more significant, honestly, because it was a city before it, and then it turned that city into our government, which it's basically corporation on top of corporation. But I just find it very interesting that's the year he left. Maybe and just filled with disgust, maybe. So
Yeah,
so
well, because I think you saw too, it's like, when they got their government in 1871, that now gives them sort of municipal and administrative enforcement power over anybody that's a member. And I think
yeah.
that's important to keep in mind.
Yeah, yep, exactly, exactly. So from 1871 to 1878, between leaving NYU in 1871 and joining Hastings in 1878, Pomeroy continued in Rochester's private practice while producing two major treatises, Remedies and Remedial Rights by Civil Action in 1876, and a treatise on the specific performance of contracts, 1879. Oh, excuse me. During this period, his engagement with California's civil code debates deepened, and the systemic critique of code literalism that would animate his Hastings era writing was already forming. And yeah, I mean, so yeah, he's going into private practice and he's writing books, dude. He's like, this is some bullshit right here. He's writing books on exactly how to interact with these systems that they're forming around us.
And it's
Uh,
interesting that he writes a treatise on the specific performance of contracts right around, this post 1871 period, and,
yeah,
remedies and remedial rights by the civil action. Now we're starting to get into where everything is on the civil side. Everything is basically contract based. I think they were teeing up to get all of that in place. And so he started writing equity jurisprudence treatises on how to navigate that.
yeah. That's specifically what remedies and remedial rights is about, right? Isn't that what we were just talking about a little bit ago? It's exactly the central argument is formed. Yeah, pursued descendant from the Field Code of 1848 that it did not abolish the substantive distinction between legal and equitable rights. That's exactly what that book is about, right there. Is everything that they're trying to change on us. So, I mean, what a good man, just going out there and seeing something he doesn't like and saying, this is the only way I know how to do it. So, this is what I'm going to do. I find that honorable. So, Hastings College of Law, 1878 to 1885. The California legislature established Hastings College of the Law as a department of the University of California in March 1878. Sir Ernest Clinton Hastings, California's first Chief Justice and third Attorney General, selected Pomeroy to build and lead the institution's educational program. Pomeroy delivered the inaugural address on August 9th, 1878, and for the first 2 years served as the school's sole professor. Designing the entire curriculum and teaching 10 hours per week, he used a printed syllabus of topics with list of illustrative cases, emphasizing that the student must be taught and accustomed to acquire knowledge for himself. Exactly, end quote.
Amen. Amen.
Amen. Yeah. I love it. The approach produced notable alumni. Elihu Root. Oh, I missed that before. That's fucking interesting. Do you know
Yeah,
who
I
Elihu
saw
Root
that and I
is?
immediately thought of you last night. I was like, I bet you'd have something to say about that.
Yeah, that is very fucking interesting because Elihu Root, he is very involved in the whole orphan trains thing. He was a litigator through that whole thing. Hmm. I missed that before. I'm gonna have to make a note of that actually. We're gonna
Well, the
put
thing is, the way that they got control over this country was by using equity almost against us. And so it would make
that
sense. It would
yeah,
make
that's
it
why
would make
that's so
sense that
interesting.
all these ninjas are in there learning from the equity masters. So that's like, well, I mean, that's one of the rules of what is it? The art of war, which is you have to know your enemy. And that's what they
Yeah.
were doing. It's like, well, we got to know what these equity guys are doing because we're going to have to use it.
Yeah, yeah, interesting. Oh, yeah, and then see, yeah, later right here. So later, U.S. Secretary of State under both McKinley and Roosevelt, spent 2 years studying in Hastings Library under Pomeroy's direct supervision. That's fine. I missed that before. That's fucking interesting. Yeah, because he was under McKinley and Roosevelt, and we both know there was a lot of shit shaking during the Roosevelt era. And yeah, that Elihu Root, he's supposed to they call him some sort of savant. He knew like 7 languages or something like that. Super smart guy, but and smart in the wrong way. Smart in the opposite way that Mr. Pomeroy is here. So, anyways, moving on from that. During the Hastings years, Pomeroy published a treatise on equity jurisprudence, co-edited by West Coast reporter with his son Carter P. Pomeroy. Uh, he co-edited the West Coast Reporter with his son Carter P. Pomeroy and appeared as counsel in 3 significant California cases testing corporate and environmental law. He died of pneumonia at his San Francisco home at the corner of Clay and Hyde Streets on February 15th, 1885. So, yeah, that very interesting life and career of Mr. John Norton Pomeroy there. So you got anything else before you want to add before we move on to I just want to briefly touch on all of his legal works real quick.
No, I've actually got something to say about this next work because I read the first section, the first subsection of the introduction to this next work we're going to talk about last night, and I'll just say that it if you ever want to read the most beautiful poetic thing that you ever could about municipal law, then read an introduction to municipal law. It's amazing.
All right, yeah, let me read the description of what the book is, and then you can talk about it a little bit. So his first book that he wrote was An Introduction to Municipal Law, and that was written in 1864. Despite its title, this work is not a study of local government law in the modern sense, but a systemic examination of the positive law of the state. Excuse me. The law emanating from the sovereign political authority and its historical development. Pomeroy surveys the source and nature of law, codification theory, the constitutional limits of legislative power, and the specific problems of American federalism, with attention to contested contemporary questions, including legislation related to married women and the war powers of the president. Damn, I bet that thing is fire, bro.
Yeah, when I saw that they're talking about the war powers of the president because obviously this is right during the Civil War era, and so he's looking
Mm-hmm.
at the war powers of the president.
Yep.
The what is it? Legislation relating to married women. I think they're going to tee up for the women's lib movement, that
Yep.
kind of thing. Like I
Yep.
said, I just read the first subsection, which was only like 2 or 3 paragraphs, and it's you wouldn't think, oh, municipal law, that sounds dry and boring, but for the subject matter that we talk about on this podcast, I can't wait to tear into it.
Yeah, honestly, I had never until I put this together, I had never even really considered breaking into that book because I was under the, making an ass out of myself, making assumptions here. I assumed that it was a book about local government laws in New York, but it is very specifically not that. So, yeah, and it's the source of nature of law, codification theory, and the constitutional limits of legislative power and the specific problems of American federalism, which is why people didn't like Joseph Story because he was a federalist very much so. That's a very interesting distinction there. But yeah, man, we're definitely gonna have to break into that book. That sounds very interesting. So this brings us to his second book, An Introduction to Constitutional Law of the United States, released in 1868. And this is a systemic introduction to federal constitutional law organized around the structure of American government and the relationship between federal and state authority. Pomeroy designed it explicitly for students, both legal and general, and organized it for consecutive reading rather than reference use. Which that's interesting. You won't find very many treatises like that. Reflecting his pedagogical conviction that students should engage directly with primary legal materials. Yes, amen to that, Mr. Pomeroy.
Yeah, we say
Uh,
that all the time. Reference
yes,
material.
yes,
Go to the source
absolutely.
material.
Go to the source material. Yes, I love it, which is that's what we're trying to do. We're going to go right to the source material after we're done talking about Mr. Pomeroy's literature, in fact. And so that brings us to his third book, Remedies and Remedial Rights by Civil Action, 1876. The central argument is that the reformed American procedure descended from the Field Code of 1848 did not abolish the substantive distinction between legal and equitable rights, but merely merged the procedural forms in which they were enforced. Pomeroy builds a systemic taxonomy of quote unquote primary rights and quote unquote remedial rights to demonstrate that equitable remedies survived codification intact, grounded in the nature of the underlying right rather than the form of the action. Which this is another book that we're going to have to dig into, because this is basically everything that we talk about right here. The
Yeah,
distinction
I'm actually
between
I think I'm gonna try to pick that book up sometime today, because that statement right there, that the primary rights and remedial rights, they're grounded in the nature of the underlying right rather than the form of the action, which
yes,
again goes back to our previous equity episodes, that
yes,
equity looks to the substance rather than the form. And just because you
absolutely.
don't get the form right, or you might be a little awkward in the pleading or here or there, if you're invoking primary remedial rights, that is what is going to be acknowledged.
Yes. Yep, that's absolutely right. Yeah, I'm gonna have to find a copy of this too, because like I said, that's I've only looked into really his treatise on equity jurisprudence before. I knew he'd written other books, but I'd never really gotten a chance to dig into these. But now that I'm understanding these, he's quickly becoming my favorite author. Story, he might kick Story out of his place, man. He's pretty fucking good, dude. Pretty fucking good. So that brings us to his fourth book, A Treatise on Specific Performance of Contracts. And this is a systemic treatment of specific performance as an equitable remedy for breach of contract, surveying the conditions under which American equity courts would grant the remedy, the clauses of contracts susceptible to specific enforcement, and the the defenses available to the defendant, including inadequacy of consideration, hardship, and latches. So that's all basically a book on how to defend yourself, which definitely gonna have to start looking into that one too. And that brings us to his most prominent book, the one that I dig into the most, and the one that he is most known for. Also, his biggest book, A Treatise on Equity Jurisprudence as Administered in the United States of America. Pomeroy's masterwork, the central argument is that equity jurisprudence is not historical curiosity or a catalog of exceptions to the common law, but a living systemic jurisprudence of rights and remedies that survived the merger of courts under code procedures intact. He organizes equity around its fundamental principles, the maxims of equity, rather than around its procedural form, and insists that those maxims are fully operative in American courts, regardless of whether a separate court of equity exists. The work ranges from foundational analysis of jurisdiction and standing through the full range of equitable doctrines, fraud, mistake, trust, mortgages, the equity of redemption, specific performance, injunctions, to an extended treatment of equitable remedies. Yeah, so that's talking about his 2 volumes on equitable remedies.
You
So he
know
really,
what's
go ahead.
what's interesting about that is they say that the full range of equitable doctrines, and there's 7 of them: fraud,
Oh,
1;
yeah.
2, mistake; 3, trust; 4, mortgages; 5, the equity of redemption; 6, specific performance; and 7, injunctions. So right there, there's the 7.
That's all I need right there, bro. That's all I need. Because as we know, what we were just talking about sevens in the Bible last week, weren't we?
Yeah,
How they're just freaking everywhere, man. Just freaking everywhere. So yeah, anytime there's a 7, I'm paying a lot more attention. That's a good catch. I didn't even catch that. So yeah, good catch. All right. Um, and then he does. Okay, so yeah, he's got 2 more books, and then after that we are going to have to. We are running out of time. We only got about 15 minutes left, so we're gonna have to run through this case real quick. So he wrote 2 more books, Lectures on International Law in Times of Peace. That was in 1886, a systemic treatment of international law in peacetime, organized from lectures Pomeroy delivered at Hastings during the 1880s. Wolseley organized and edited the manuscript after Pomeroy's death. Oh, this is a posthumous work, representing Pomeroy's only sustained engagement with public international law. Nice. And then a treatise on law on riparian rights and analysis, 1887, an analysis of riparian rights doctrine as applied in Pacific states, including California doctrine of prior appropriation, which diverged substantially from English common law riparian model by permitting prior apparitions to hold water rights superior to riparian landowners. It's basically land rights in California. That's what that's about. So yeah, we don't have time to really go through his whole legacy and his contributions into all of the legal jurisprudence in the world, but we are going to get much further into Pomeroy in the second hour. Because right now what we need to do is we need to move on. We've did a pretty good job on Pomeroy there, but now we need to move on to the Supreme Court case that I want to talk about today for a very specific reason. I want to open this subject up with this case so people know right off the bat. The Supreme Court, this is something straight from the Supreme Court. This is, a very established doctrine in equity jurisprudence, like I said, and you can even find equity of redemption in the rules of civil procedure. You can enforce these rights through the law, but it's going to be a lot harder for you. You just want to keep everything in the exclusive equity jurisdiction, which is what this case is too. So, without further ado, let's move on. This is Pog v. Davis, 96 U.S. 332, and we are actually going to go through, we're not going to start at the syllabus because I think going through the actual factual background and everything is actually helpful to me. Sometimes this is how I read Supreme Court cases. I'll read the opinion first and then go through everything because the opinion usually lays out everything that happened in the case. So that's how we're going to do it today. We're actually going to start breaking down the opinion of the court so everybody has the factual background and you can understand what we're saying. So in March 1857, Pog borrowed $2,000 from Davis at a monthly interest rate of 3.75% and executed as security a deed of 2 Washington City squares. The deed was absolute in form, purporting to be a $2,000 sale. The March 1857 loan was paid at maturity and the deed returned. In May 1857, Pogue borrowed a further $1,500 under the same terms and redelivered the same deed as security. Okay, so he got the deed, got the loan for the deed, paid off the loan, and then he came back for more money from Davis. So when the May 1857 principal went unpaid, Davis placed the deed on record in September 1857 and January 1858. A third party brought ejectment suit on a tax title, purporting Davis to be demanded repayment without success. So basically, Pogue defaulted on the loan, and because of that, Davis put the deed on public record for, he wasn't necessarily selling it, but he put it on record that it's up for ejectment. You could come get this piece of land. So somebody in January of 1858, a third party brought a suit of ejectment on a tax title. I'm assuming he was trying to do some sort of tax suit here. But because of that, that prompted a demand of repayment from Davis because the deed was in his name. But obviously that was unsuccessful. So on February 9th, 1858, Pogue obtained an additional $500 from Davis. Pogue is the original $1,500 loan. He obtained an additional $500 from Davis and executed a sealed instrument containing a general warranty of title and a specific covenant to indemnify Davis against losses from the pending litigation. And indemnify, that's a weird word not many people know. To indemnify, also known as indemnify, or indemnity, means compensating a person for damages or losses they have incurred or will incur related to a specific accident, incident, or event. So basically, he borrowed another $500, and in the contract for that $500, they put a stipulation in there that Davis would be indemnified against losses in the pending litigation because obviously Pogue is he's wrapped up in this litigation over the $1,500 he didn't pay back. So Um, yep. Accompanying the February 5th, 1858 instrument and bearing the same date, Pogue gave Davis a receipt for $2,000 that purported to be full payment for the purchase of the land. The controlling question was whether the February 1858 instrument, read together with the testimony, released Pogue's equity of redemption. Pogue calling the $500 an additional loan, Davis calling it the purchase price for the equity. So that's the dispute. Pog is just calling it another loan, like the original $2,000 loan, and Davis is calling this a purchase of the price of the equity. So basically, um, uh, he's purchasing his way out of his equity of redemption.
Oh, so this is his defense where he's saying, oh, basically right here
Correct.
is he is transferring his interest and he's giving up his equity of redemption by asking for this because that's what the defense is alleging. Like, well, this amounts to a waiver of the equity of redemption and I'm
Yes.
purchasing the mortgagor's interest.
Yes, that's exactly right. Yeah, that's what Davis is claiming he's doing. He's purchasing the mortgage's interest so that he's basically trying to get Pogue out of it, saying that Pogue has no equitable interest in this property anymore because of the additional $500 loan. But Pogue is saying, no, that has nothing to do with the original purchase price. And Pogue gave Davis the receipt for the $2,000 that purported to be full payment for the purchase of land. So, like, if we remember that Pogue already paid this land off, and then he got an additional loan from Davis for $1,500, and he basically put up the land as collateral for that. So, and then through this, Pogue is obviously a smart man. He gets an additional loan and calls it a loan, doesn't call it a purchase of the equity like Davis is trying to call it. So I think Pogue understands what is going on here. So, but then we get into the what are the doctrines of this case? How was it adjudicated? How did Justice Field come to his conclusions in this case? So doctrine 1 is absolute deed is mortgage. Parole evidence, not parole, not like prison parole. I actually got the definition of that. Parole is means giving express like verbal consent to something. That is when you parole evidence to someone. It's verbal consent. So it establishes equity doctrine that a court of equity looks beyond the form of the deed to the real transaction. When the real transaction is one of a security and not sale, the court gives effect to the actual contract of the parties. The verbal evidence rule governs that language of the written instrument and cannot be varied, but it does not forbid inquiry into the object that the parties had in executing the instrument. A deed may therefore be shown to have been given to secure a loan. The object of the parties in such cases constitutes a ground for equity's exercise of jurisdiction, which the court always asserts to prevent fraud or oppression and to promote justice. So maybe that was Pogue's whole thing here, was he knew that would get him into a court of equity by taking that additional $500. So
yeah, because he knew that he had a benefit that would count as a beneficial interest, and he would try to leverage that in order to, take the other guy's equity out.
Yeah, I think that's what was happening here. Yeah. And so doctrine 2, the inalienability of equity of redemption at loan's inception. So the equity of redemption is so inseparably linked to a mortgage that the borrower's right to redeem the property upon payment cannot be waived or abandoned by any contemporaneous stipulation, even one embodied in the mortgage itself. So basically what that's saying right there is the equity of redemption is so tied into mortgages and how that they work that even if you stipulate something within a contract at law to waive the equity of redemption, that does not necessarily waive the equity of redemption unless you do it in a very, very specific way. Because as we'll learn in hour 2, we'll learn how mortgages how you gain equity in mortgages and you turn these things into mortgages and trusts and these types of things. We will learn how that equity comes to arise through a mortgage, and that is why is so inseparable from mortgages. That's why you can't separate it from it. So moving on from that, the doctrine protecting the equity of redemption exists between debtors under financial pressure will often submit to oppressive terms in hopes of repayment before the conditions are enforced. I feel like I had another point with that. What am I forgetting? It's debtor. Oh yeah, it's made. So this is a direct quote from the case. Its maintenance is deemed essential to the protection of the debtor, who, under the pressing necessities, will often submit to ruinous conditions, expecting or hoping to be able to repay the loan at its maturity, and thus preventing the condition from being enforced or properly sacrificed. So basically, what he's saying there is most people screw themselves out of the equity of redemption. So we'll move on to Doctrine 3, the requirements for a valid subsequent release. Although a subsequent release of the equity of redemption to mortgagee is permissible, the transaction will be closely scrutinized to prevent oppression, especially when the creditor has shown readiness to exploit the borrower's necessity. A valid release cannot be inferred, and that's a release means to cease or to be bound by obligations. You're just stopping the contract. That's what a release is. A valid release cannot be inferred from equivocal circumstances or loose expressions. It must appear either in writing that expressly imports a transfer of the mortgager's interest, or in fact sufficient to stop the mortgager from asserting any claim. So, it must.
So I think what they're saying there is that because you can get rid of your equity of redemption, but it must be through an explicit assignment where you are transferring your interest either to a mortgagee or somebody else. It has to be legitimate, and there has to be adequate, valuable consideration to show that that interest is in fact being transferred lawfully.
Right, and it has to be by the mortgagor. That's the part I was trying to remember right
Yes, it
there.
cannot
Yes, it
be
has to be by the
imputed by the
mortgagor.
mortgagee saying that,
Right.
oh, well, he did this, he did that. Look, he's waiving his equity of redemption, therefore I win. You can't do that.
Right. Exactly. It has to be directly stipulated, expressly imports the transfer of the mortgagor's interest. The mortgagor has to be expressly transferred of the interest in the mortgage. So, and the last point on this doctrine is the consideration must be adequate, meaning that would be reasonable between unrelated parties dealing in similar nearby property. Any marked undervaluation vitiates the proceedings. Okay. And then, yeah, so then we get to the applications of the facts. How do they actually apply this doctrine in the case? The party's testimony was indirect and irreconcilable conflicts. In addition, the defendant's recollection was contradicted on several material points, including his denial of receiving interest installments, which were disapproved by his own endorsed checks. And yeah, we don't really need to dig deeper on that. We'll dig. We'll kind of get into that in the second hour. So, multiple Washington City real property dealers testified to property value roughly 3 times the secured amount. It is contrary to the ordinary course of affairs for a party free from fraud to surrender an interest at so manifestly inadequate a price. So no valuable consideration. The tax title adverse claimant relied upon at trial was in fact worthless. Pronounced so by an experienced title searcher and subsequently so proved, making the claimed cloud on title an insufficient basis for low payment. So basically, the whole reason this thing came to be, the adverse tax claimant, it was completely worthless from the beginning.
It's interesting they say that it was an inadequate cloud on the title because anytime that somebody makes a claim on another title, whether through a lien or whatever else, it's said to have a cloud over it. And they're saying that, well, that cloud is actually inadequate because of the valuable consideration and everything underneath it. So invalid cloud. So they were basically upholding his claim on his title.
Yep, exactly. And then so that and the February 1858 instrument on which Davis chiefly relied contained no formal transfer of the mortgagor's interest. It merely warranted title and indemnified the grantee against pending litigation losses, confirming its language to the absolute face of the original deed rather than affecting a release. So Davis or Pug played his cards right, and because in that additional $500 loan, none of the interest of the mortgagor was transferred. So that means that the equity of redemption was not transferred and is still reliable. So the conclusions in terms of relief, the court concluded that Pog had never conveyed his interest in the property except as security, and the deed remained a subsisting mortgage entitling him to redeem. Interest would be allowed only at 6% per annum, not the contractual 3.75% per month, because the stipulated rate was forbidden by statute and would rapidly have consumed the entire estate. And that's equity follows the law right there. That's another equity maxim they snuck in there. And see, and that's another thing with like these equity cases and stuff. Nowhere in it does it say we are doing this because equity follows the law. But that is exactly why they changed the interest payments on the new contract, was because equity follows the law, because there was no stipulated rate forbidding statute. So, and then the last point, Davis was to be charged a reasonable sum for use and occupation of the premises from time he took possession in 1865 and credited for taxes paid and other necessary expenses he had incurred. Okay, so, and then that's, I wanted to read, so that we went through the whole case there, and then I want to go back up to the very beginning of the case, because in the beginning of all Supreme Court cases, the court reporter is going to go through and make it easy for the Supreme Court justices, and they're going to give them the 5 point, however many points there are to be considered in this case. And there are 5 in this specific case, and the one I want to focus on here is number 2, and that is because this is an actual this is what's called a holding in this case. So that you could take this to any court in the United States as a holding, like, hey, this is what this says in this case, bring it to a judge, and I mean, they're really not going to have much to argue with it. And the reason I wanted to bring this one up is because an equity of redemption is so inseparably connected with a mortgage that it cannot be waived or abandoned by any stipulation of the parties made at the time, even if embodied in the mortgage. So we had already went over that a little bit, but I did just want to show everybody in the actual case that's right up at the beginning. The equity of redemption is so inseparably connected with a mortgage that it cannot be waived or abandoned. And why this is so important, and we're going to get into this in the second hour, is there's a lot of people out there today with mortgages, and they don't understand what they're signing, and they don't understand what the equity of redemption is. They don't even understand what a mortgage is. They really don't understand anything. They don't understand what they put their signature to. And that is what we're here today to do, is I'm trying to sign a little light on these things to show people that, you know, not everything is bad and scary, and you're not all fucked, and the sky isn't falling, people. There are remedies, we have rights, we have things we can do. So you got anything you want to say before we head to the second hour?
Yeah, you're the, like, in a mortgage, you are the one that are issuing the note.
Exactly.
Therefore,
and that's going to become very important when we get into going through Pomeroy's equity of redemption stuff, when you realize that you're the mortgagor, not the mortgagee.
Yes, and that note has value, or, you know, it's worth an amount. And so if you issue that and, you know, they end up, you know, taking the collateral back, it's like, okay, that's fine. Give me my note back and anything that was made on it.
Give me the full accounting on that note.
Yeah, give me the full accounting on the note, and then also, it's fine. You can take the house. You just got to give me all my money back, right?
Yeah.
Because initially you gave them the note, which was, as you know, that's basically the value. That's basically the money.
That's what that's what this whole case rested on, was the notes that they were passing. Yes.
Here's a note, which is money. You give me the house. Oh, well, what's that? You want the house back? Okay, give me my money back. And that's basically what the equity of redemption is, and that cannot be waived, even if it's in the contract initially.
Yeah, yeah, and we really didn't have time to get into. I know it was a little confusing at the end there because what happened is they ended up writing a new contract after all of this stuff was done. I didn't really want to get into the specific nitty-gritty of that, but they ended up writing a new contract. That's what this percentage stuff is, and that's with the equity of the follows the law thing. But yeah, so oh shoot, I just forgot my point I was making there. Anyways, it doesn't matter. It doesn't matter. We've made our point here, and like I said, the reason I wanted to bring that case up is so everybody, it's a little primer for everybody to realize that, like, you know, it's not just two weird dudes on the internet talking about this stuff. We're drawing
Wow.
these. Well, right. Not only two dudes on the internet talking about this stuff. So the Supreme Court also talks about this stuff too. So, and you know, and this is an established doctrine all the way from the beginning of America. 1879 is when this stuff is from. The Judicature Act is what we just talked about before, and we've already proven it out. Scalia told us nothing has changed since the Judicature Act. So
That's amazing.
That's all, isn't it? Though, you got anything you want to add?
No, I think that's actually a really good segue because I think we're going to be starting to get into Pomeroy next, which has to do with what we're talking about in hour 2.
Yep, that's exactly right. In hour 2, I hope to see everybody over there. It's going to be a spicy nugget, man. You are going to get so much good material. I mean, it's just going to be overflowing with gravy, dude. You guys are not going to want to miss this, and it is directly relevant to everything that we're talking about today. If you got a mortgage out there, you're living in a house, you got a mortgage on it, you better come to the second hour. That's all I'm going to say. So, without any further ado, never forget to seek truth and honor the Creator above all, and let that be the whole of the law.
That's the important thing here, is that everyone's word should be meant for a use.
And the words that I'm using today are meant to pull down idols within people's temples.
Meaning that I want to destroy
Falsities that they have idolized.
for their entire life.
And just pull those out and sweep them clean. And before that temple,
And get reinfested with a new lie. Give it true life.